Good. Good morning, everyone. My name is Karen Gagnon. I'm a Senior Benefits Advisor with the United States Department of Labor, and I work for the Employee Benefits Security Administration. I'm here today to talk to you about health plan administration, talk about the Affordable Care Act, how it interplays, and talk about some things that you may be wanting to pay attention to as a broker, a health underwriter for your clients. So I wanted to give you a little bit of information about myself. I've been with the agency for about 4.5 years. I have been in the health and welfare industry for a very long time. I've about 25 years private sector, employee benefits, health and welfare, a little bit of pension, and now with the agency, I've been with them for, like I said, 4.5 years. And as a benefits advisor, we do work on an informal basis, assisting participants, beneficiaries, employers, service providers, attorneys, brokers, whomever, to ensure that the employer-sponsored health plans, private sector employer-sponsored health plans that are protected by ERISA are maintaining their compliance with the regulation. And I'm very happy to be here with you this morning to present some information to you. I do understand that there's not an option to have questions posed through this live stream. If you do have questions after the meeting or after the presentation, please email Kate, and then she will forward the emails to me or the questions to me, and we can get back to you. So with that, I want to explain a little bit about our agency, and we'll get right into it. So the Employee Benefits Security Administration does work in conjunction with ERISA, Title 7 of ERISA, Title I, Part 7 of ERISA, and it does cover all employer-sponsored health, welfare, and pension plans on the private sector side. We have absolutely no jurisdiction over public sector, so federal, state, municipal, and church plans. They fall outside of our jurisdiction, so we are unable to assist those individuals. The Employee Benefits Security Administration does have offices regionally located throughout the United States. The Boston Regional Office, where I work, does in fact cover all of New England and upstate New York. Hence why I'm here today. So with that, I just wanted to give a little bit of history about EBSA. So we are basically a component, or we've been arranged because of ERISA, Employee Retirement Income Security Act, which was passed back in 1974. And originally, probably, if you've been in the field for a while, probably remember us as the Pension Welfare Benefit Administration. Well, we're now the Employee Benefit Security Administration. In my office, we have benefit advisors like myself and investigators. The benefit advisors do work on an informal basis, assisting folks with front lines, assisting individuals with concerns, questions, issues, problems. And if there is a problem, if it's a compliance issue under ERISA, then we're going to work with the service provider or the employer to get the plan into compliance so that the employees are in fact getting the benefit that they're entitled to. We work with employees, we work with former employees, we work with retirees, we work with beneficiaries. So whomever is entitled to a benefit, we are working with them to ensure that they're getting what they deserve to be getting or what they're paying for. Our office is staffed Monday through Friday from 8:30 a.m. to 4:45 p.m. And I would encourage you, if you have questions that you don't get through to Kate, to call our agency directly. The phone number to call Boston directly is 617-565-9600. That would be answered by whomever is staffing the front desk, our receptionist, and it would be then transferred over to a benefits advisor. We are available live, as I mentioned, Monday through Friday during the hours of 8:30 a.m. to 4:45 p.m. And we are pretty much about 95% of the time, if not more, able to take your call live. On the chance that you had to leave a message because we were all busy, or we were in a department meeting, or like yesterday we were all in a training session, you have the opportunity to leave a voice message, and we will get back to you hopefully that same day, if not the same day, by close of business the following day. If you were to go on EBSA's website, we do have opportunities to submit web inquiries if you don't have the opportunity to call us. If you were to submit a web inquiry to us, we would respond to you no later than 2 business days to let you know that we received it and to either ask more questions or provide the answer to your question. So with that, I'm going to jump right into the Affordable Care Act and what I wanted to cover for today. So as far as ACA, I'm sure you're all aware, it's been around for a long time. It was passed back in 2010, March 23rd, 2010, and it did become effective for plan years beginning on or after September 23rd, 2010. With that, There were pieces that rolled out right away. There were pieces that have rolled out over the years. We have pretty much, except for the Cadillac tax, had all of the affected parts of ACA roll out. And we just want to talk about some of the more current popular things and then move forward to anything that we have. Now, we had an in-house presentation yesterday on health plans because that is a big push for us, and I wanted to present a little bit of information to you on things that you may be looking forward to, making sure your clients are being covered in whatever, because we do investigations. So as I mentioned, ACA was enacted back in 2010. We cover, as I mentioned, private sector group health plans, the health insurance issuer, and we cover both fully insured and self-insured products. The insurance department in each respective state has jurisdiction over fully insured products only. EBSA has jurisdiction over all. So if an employee or a former employee was to call us on a fully insured product, we would help them the same as we would with a self-insured. If they contact the insurance department and it's a self-insured benefit, it's going to get referred to our department, to our agency, for further follow-up and communications back with the participant. We do not have jurisdiction over very, very small health plans, and that would be less than 2 participants. We do not have jurisdiction over accepted benefits, as in a retiree-only health plan. If an employer sponsors a retiree plan and they lump it in with an active employee plan, it falls under our jurisdiction. If an employer has a separate, segregated, retiree-only benefit, falls out of our jurisdiction as far as the Affordable Care Act. It still falls under our jurisdiction for benefits, but not for the Affordable Care component. And as I mentioned, church and governmental plans, we do not have any jurisdiction. Accepted benefits, basically accepted benefits in all circumstances are generally not health coverage type benefits. So an example to that would be a vision plan is not considered a health plan and is not subject to the rules and regulations of the Affordable Care Act. Another thing that would be an accepted benefit, which is one of the things we have a lot of issues with, would be what we consider a payroll practice. A payroll practice would be a type of a benefit that an employer has no sponsoring to. So they are not negotiating contracts, they're not negotiating rates, they're just saying, okay, Mr. Employer, Mr. Bennett, our insurance company, come on board, talk to our staff. If they choose to sign up, everything is between them, you, and as a courtesy, we will withhold monies from their paycheck and forward the premiums to you on a regular basis. One of the most popular ones is like an AFLAC type benefit. So our agency does not have any jurisdiction over those types of benefits. So it must be sponsored by the employer for us to have jurisdiction. There were some final regulations that were posted back in October of 2014 regarding limited scope vision and dental and employee assistance programs, and they were basically to determine if in fact they were to fall under the guidelines of the Affordable Care Act. If the vision and dental are wrapped into the medical plan, they do fall under those jurisdictions. If they don't, they're outside of the Affordable Care Act. And that did become applicable as of January 1 for plan years renewing on or after that date. The other newest piece is the wraparound limited coverages, and those did become effective earlier this year. As far as accepted benefits on the limited scope dental and vision, in essence, they are not an integral part of the plan. The participants can, in fact, decline the coverages, and the claims for the benefits are administered under a contract separate from the insurance for the health plan. So EAPs is a big thing that's been coming up recently, and is the EAP considered a health plan? In some cases, the answer is yes. In some cases, the answer is no. It comes back to what type of benefits are provided by the EAP program. If the EAP program is in fact providing any kind of medical services, it is considered a group health plan, and employers need to ensure that they are following the Affordable Care Act rules and regulations for the EAP as well as their health plans. If it is nothing more than, and I don't mean to belittle that, but if it's basically a referral only, so the employee's calling up, they're explaining their situation, it's being triaged, and they're being referred appropriately, that is not considered a group health plan. Therefore, the employer would not have to follow the guidelines of the Affordable Care Act. And another piece of that is if there are no employee contributions, most likely it's not a health plan, but it's just something to pay attention to with your clients as you are in fact looking at renewals, especially at this time of the year, which is probably your busiest time of the year. So moving on to the pre-existing conditions, this is something that I've left in the presentation only because there are cases where we're still getting calls on pre-Xs. As we all know, pre-existing condition clauses did go away for plan years beginning on or after January 1, 2014. No plans are allowed to have them as a condition of coverage. So again, it became effective on January 1, and it's just something that employers should be paying a lot of attention to ensure that their employees are not coming to the Department of Labor because of denied health claims for pre-X. Watch out for hidden pre-Xs. So what is a hidden pre-X? There are times that a claim will get denied because they said the accident did not occur, if it was an accident type thing, while the participant was covered on the group health plan. That's a huge no-no, and I just caution you folks to pay attention to that because it is something that comes to our office and then ends up becoming something that we're going to the employer on. So backing into going to the employers, we do work informally. We will determine if there is an issue when we get a call from somebody, and if there is, we're then contacting the employer, who may in turn contact you folks or may direct us to you folks. We are looking to keep the plan in compliance. We're looking to ensure, as I mentioned previously, the employees are getting the benefit that they're signed up for and that they are paying for. So the biggest takeaway from that I can suggest, this came up recently at a presentation I was doing with some Taft-Hartley representatives. They said, what is it we can do to make sure that we're okay? The biggest thing I can throw out there is when employees are talking to the employer, when they're having problems, the employer should take it to heart and look into it. Because if it's not, that's when they come to us and that's when we go to the employer. And it's just a suggestion that we throw out there just to, in fact, make sure that everybody is getting what they need and there are not compliance issues. The 90-day waiting period, I've also left this into our presentation. This is very important because an employer can no longer impose a waiting period for coverages of greater than 90 days. And this did become effective this year. So I just want to throw it out there. There is one caveat to that, and that would be if an employer has a bona fide orientation period. If they have a bona fide orientation period, meaning that every new hire comes on board and there's a 30-day window where the employer and the employee are evaluating each other for job match, job fit, and at the end of that 30 days, the employer can say, nope, you're not staying, or yes, you are. And they really don't consider that a time of employment. They're working, but it's just an evaluation period. An additional 30 days can be added to the 90-day wait. Short of that, the most time somebody can have as a waiting period is 90 days, and we do look at that very carefully. Okay, there's some question about per diem employees or variable hour employees, and the department has been very strong about indicating that we do have rules and regulations regarding how they want to look at that. But most importantly, the IRS is really overseeing how that is being viewed, and are the employees in fact being counted as full-time employees, and the look-back period being appropriately defined to ensure that these folks are getting the benefit that they're deserved to get. One of the things I probably should have said at the very onset is the Affordable Care Act is a tri-agency jurisdictional regulation. So Health and Human Services has a component of the Affordable Care Act. It's really the Patient Protection and Affordable Care Act. They have jurisdiction over all of the marketplaces. They also have a lot of jurisdiction over the benefit in general, how it was originally designed and created. The Department of Labor has jurisdiction over the employer-sponsored ERISA benefits. And then Treasury has certain components of it. So there are not times that one agency can answer all questions, and we may need to refer appropriately, or they may need to refer appropriately. But it is out there, and if you called us and it wasn't us, we definitely could get you connected to somebody that could give you more information. Wanted to jump into wellness programs. So wellness programs, as of now, are here to stay. We have not heard of anything that's going to make them go away. There have been some challenges in the court system by the EEOC, thinking that sometimes the wellness program, when an employer is asking for a health risk assessment on not only the employee, but on family members, that possibly it's violating some rules and regulations, or some HIPAA or GINA. Well, the court system have determined that that is not a viable case for the Affordable Care Act, and it does not violate affordable care. So employers can, in fact, request that their employees and their covered dependents go through health risk assessments or through wellness, different aspects of wellness programs without any problem of it being out of violation. There are a couple of different types of wellness programs. There are activity only and outcome based. On any wellness program, the key to it being in compliance is who is evaluating the results. If it's an outcome-based benefit or an HRA, if the results are going to an independent third party like your insurance carrier or TPA or just another company doing it, and all the employer is getting is an aggregated result, that is fine. That is not out of compliance. Then the other piece of that is that the employer cannot use the results in any adverse employment decisions. If they do that, they're out of compliance. If the employer is getting it, well, now they're violating HIPAA. So as long as the information is being produced and resulted to somebody else and all the employer is getting is an aggregated result, there's not an issue that the court system has found to date. There are 5 requirements for a health contingent wellness program. Those have not changed. Those have been around for a very long time. The one thing that's recently changed is on rewards, that the employer can reward up to 30% of the cost of the individual coverage for a health contingent wellness program. And if it's a smoking cessation, they can reward up to 50% of the cost of the individual only coverage as an incentive. Question that we had quite frequently a little while back is it allowable for an employer to incent somebody to participate in a wellness program? And then there was the question, well, what if they disincent, if you will, for lack of a better term? Is that in compliance? The department has taken the viewpoint that it's really synonymous. If they give them a bonus or they take something away, as long as they're treating all similarly situated employees within a class of individuals the same, then they're not in violation. So if they were to say all employees must do a health risk assessment to not have to pay a higher premium, that's fine, because again, the employer is not receiving the results and everybody has the same outcome. And it's not contingent on what the outcome says, it's just contingent on doing the actual health risk assessment. If the employer says, if you don't do the assessment, we're going to charge you a higher premium, higher deduction, that's perfectly in compliance and not doing anything outside of the rules and regulations. So I just wanted to bring that up because it has come across our desk on numerous occasions. And it's here to stay from what I can see. And as I mentioned, the EEOC did challenge it. And as of a year ago, the challenge was shot down and has not been overturned or has not come back to the court system. That brings us to the prohibition on lifetime and annual limits. Very seldom do we see issues on that, but I just wanted to leave it in our presentation just to remind you that that is still out there, making sure your clients are paying attention to that and are not going outside the rules and regulations. And this applies to grandfathered plans and non-grandfathered plans. There are still some grandfathered plans out there, so if your plan was in existence on March 23rd, 2010, and nothing has happened within the rules of the Affordable Care Act to have lost your grandfathering status, then the grandfathering status still applies. But there are pieces, as we've all learned, that it doesn't matter if they're grandfathered or not, they still have to apply. And the prohibitions on limits are one of the things that does not matter on the status. Everybody has to abide by that. Oops. Another thing I just wanted to bring out, this has come across our desk recently because it's that time of the year, the uniform summary of benefits and coverages in the uniform glossary, that is here to stay, and you are still required to ensure that your benefits are in fact being compiled and done in the summaries of benefits and coverages. They do not replace the summary plan descriptions. We get a lot of concerns that it has replaced the SPD. It doesn't. The two of them still both of them have to be compiled and presented to the employee population. Now the SPD does not have to be presented to the employees until 60 days after their enrollment, or if it's a brand new plan or a brand new enrollment, up to 90 days. The SBC must be produced and presented prior to the actual benefit enrollment date or the benefit effective date, so the employees have an understanding as to what it is they're getting, and it's an apples to apples comparison. That was the impetus behind the creation of that component, because so many of the plans would have a benefit summary that was not structured the same if they had multiple plans, and so an employee was trying to look all over these various documents and not really being able to make a real solid comparison because it just wasn't uniformly going across the same line. And that's the one thing the benefits of summary, the summary of benefits coverages does, is it does make it uniform, and it is still there, and all of the templates that have been available are still required with the fonts and the pages and the gray bar and all that. None of that is changing. It's all still there and required. If you have further questions about that, certainly feel free to reach out to Kate or to my office. We'd be happy to talk to you about that. So just important that these get produced. Now, as far as the SPD, the employer is required to produce it at least one time a year upon request to the participant or the beneficiary or the retiree. As far as the SBC, it does need to be as soon as practicable prior to the effective date. So SPD always can be done after. SBC must be done prior to the effective date of the benefit. And in here it's talking a little bit about special enrollment. Just want to throw this out there because this has actually come across our desk recently, where there appears to be a lot of confusion or misunderstanding about special enrollment and how wording is done on the documents. Just caution you to pay attention to the special enrollments and ensure that when your client's employees are approaching them for special enrollment, that the language is spelled out in the SPD so that the employee knows what they're required to do, what they must have, and what's required of them to have a special enroll when they've lost their group health plan eligibility elsewhere. Okay, notice of coverage options. I've left this out there because it really is more about the COBRA notices. So when the marketplaces first went live a couple years ago, there was a notice requirement that all employers had to notify their employees about the marketplace and the eligibility of the employee to go to the marketplace and what was available to them through that. That is still a required notice. It is required that all new hires now receive that notification, and there has been some modified language on the COBRA notices, which if you are not using or your clients are not using our model notice, I would encourage them to take a look at the model notice on our website, which is www.dol.gov, DOL for Department of Labor, .gov/EBSA, Employee Benefit Security Administration. On our website, that's our homepage, you will find a wealth of information. If you're not currently subscribed to that, I would encourage you to subscribe to updates that come forth. For every update that we put out there, you'll get an email notification that an update has been done. Go to the website and check it out. All of our publications are available there. I'm going to go to a publication in a few moments. All of our fact sheets, all of our Q&As, all of our field assistance bulletins, they're all out there and they're all available. COBRA notice is under the COBRA section, and I just would encourage you, if you're not using it with your clients or if your clients aren't using it, they might want to take a look at that and make sure that they are in compliance. First thing that we're going to ask employees when they call us is, what did the employer give you? And we're going to review the docs, so either the SPD, the COBRA notice, whatever they're calling about, we're going to review the docs, and if there are issues there, first thing we're going to do is say, you're not in compliance, we need to talk about this. The next screen I've put up is just the original notice that was required 2 years ago when the marketplaces first went live. Again, it's still required. And then the last page of this screen, or this part of the presentation, is what I just mentioned about our website, and then just some contact information for the IRS and for HHS. So that concludes what I wanted to talk about the Affordable Care Act. What I wanted to go into next is the fact that our agency, we have investigators, as I mentioned, we have initiatives every year. Last year, started an initiative on the health side. Now, we've done health and pension investigations for a long time, but we've been much more focused on the pension side of recent, we have now focusing on the health side as well. So I did want to bring that to your attention, that it's there and that we are doing a lot as far as that goes. I don't have any slides for the information I'm about to present to you. It's hot off the press from a presentation we had in-house yesterday that I wanted to bring to your attention on some of the things our investigators are looking at. From there, I'm going to then go into the compliance guide, which is our Bible. This book is invaluable. If anybody hasn't downloaded it, hasn't looked at it, I encourage you to do it. If you can't do that and you want us to send you a hard copy, let Kate know, let myself know. I'll give you my phone number. We can get you a hard copy of this. It's the same as the electronic version, but these are the Bibles that our investigators are using. So, as I mentioned, this year's initiative is on the health side of it, so we are putting a lot of efforts into that. That doesn't mean that we're going to come in with a heavy hammer and we're going to be pounding on doors. What that means is we are taking all of our calls very seriously, not that we haven't, but if there are compliance issues, we are seriously looking into where things are falling outside of the guidelines and the rules and the regulations, because our whole goal is to maintain compliance. So a couple of things that came out of yesterday that I wanted to bring to your attention. Apparently we've had an issue brought to our attention, not in Massachusetts, in another state, where the state regs differ from the federal regs. And there was an agency saying, oh, well, we're following the state regs, but the federal regs are stricter and stronger, and they should be following the federal regs. And so I wanted to just explain what our senior technical health advisor provided to us. Under ERISA Section 514A, the General Preemption Rule, Title I of ERISA, supersedes state laws that relate to any plan covered in ERISA Section 4, parens A. Very important, because we're the federal government, so we are going to be looking at the federal regs, and if the federal regs are stronger and you're following state regs, there's a chance you're going to have a compliance issue, so I just want to throw it out there. We do have enforcement ability, so I did want to bring that out. We take our jobs very seriously when there are compliance issues that the employer or their service provider are not addressing and not bringing to the forefront. There are times that we will actually have some criminal or civil charges brought against them, goes before the court system, then the judge determines what's going to happen next. We do have employers that have been put to jail or sentenced to significant fines by virtue of the work that our agency has done. So I just wanted to put that out there and make you aware that our reach is very far-standing, and we do encourage all of you to work as closely as you can with your clients to ensure that compliance is always the front point of what they're looking at. What does that mean to you? Well, I got to tell you this, more times than not, I'll get a telephone call. Maybe the employee's angry, maybe there is an issue, but whatever. And we'll call the employer to get more information, because we're not going to make a snap judgment. We're not going to interpret what the employee says and take it for gospel. We're going to call and get the other side of it. A lot of times we'll call the employer and they'll say, oh, that's my broker's problem, or that my broker takes care of that, or whatever. But unfortunately, unless the employer has determined that the broker, the service provider, the third-party administrator is the named fiduciary, the employer is still liable and responsible for everything that goes on with that plan. So they may try to say it belongs in somebody else's lap, but it doesn't. It belongs in the employer's lap, and they're the ones that we're going to come after. That's not saying that if there are issues that the service provider is involved with, that we are not going to go to the service provider as well, because we definitely are. So there are times that service providers may be a deemed beneficiary, and that's also part of this year's initiative. And what we're looking at to determine if a service provider is a deemed beneficiary is we're determining whether the TPA has acknowledged fiduciary status or has contractually agreed to provide services through which it exercises discretionary authority or control over plan administration or management. You may want to look at your contracts carefully with your clients to determine if, in fact, they're waiving their fiduciary rights and throwing them to you folks, at which point we're going to be coming to you if there are issues with the plan, not necessarily the employer. Just putting it out there as a cautionary measure. Another thing that we're looking at with our initiative for this year are service provider fees. Service providers are allowed to have administrative expenses and charge fees for that. But we are looking to determine, are the fees disclosed? Are they excessive? Is the fee based as a percentage of premium? Is overhead included? Are there duplications of services? Who's receiving the compensation, and are there any party and interest transactions? Party and interest is significant. That is a huge violation, and we just caution you to pay attention to your fee structure and what is outlined in your contracts, because those are the pieces that our investigators are looking at this year as our initiative. We're also looking at reasonable claim procedures. Does the claims administrator establish and maintain a reasonable claim and appeal procedure? I would say, of the calls that I have taken in the last year or so, there's a huge percentage of denied claims that people are calling us. So an insurance company, if they're denying a claim, probably much larger than their phone number, they're putting the Department of Labor's phone number. The employees are calling us with concerns or questions. Now, we work, as I said, informally. We do not work in a medical or legal capacity, so we can't make a determination on that benefit claim. And really all we're going to tell the person is, if you haven't exhausted your appeal rights, first and foremost, you must do that to preserve your legal rights at the end if you might need to have legal rights. At the end of the day, if they've exhausted their full appeal process, the claim is still in an adverse benefit determination. The only thing our agency can do would be to reach out to the employer to validate that the insurance company processed that claim properly. Did they process it properly? Did they process it timely? Were the rules and regulations of the respective plan actually followed? If those things aren't coming with the right answers, the investigators are then going to be looking very seriously into the whole procedure for the claims processing. And determine if, in fact, we have an isolated issue, or do we have a systemic issue. If we have an isolated issue, they're probably going to say, okay, let's get this corrected, let's move forward. If we have a systemic issue, which would mean something that's happening over and over and over, similar type issue, we're going to be looking at that much more significantly and actually going through the full investigation process on the health plan and the plan that you have, the contract you have with your health plan. Under claims reviews, with few exceptions, health plan investigations will include a review and/or audit of claims procedures and claim samples. Again, this is a very driven initiative for this year, so they are going to seriously look at claims processing. We're not going to look at, again, the medical component of the processing. We are going to be looking at the types of claims that are submitted. Are they routinely all receiving the same type of response back on the same type of claim? Maybe claim ABC is continuously denied across the board. Maybe it's not. We're going to be looking at all that. We're not going to determine medically if that's the right answer or not, but we're going to be looking at the plan as an overall to determine, are they in fact discounting things they shouldn't on a systemic basis, or is this just in a one-off opportunity that there's an issue? How will they do this? They will actually request claims listings from the insurance company. They will evaluate the claims listing, and then they will analyze the claims results. Again, just throwing this stuff out there because we do have subpoena authority, so we can in fact get this. It's not protected health information when it's subpoenaed by us. The subpoena does go through the regional solicitor's office, so this is a legal document, and it will require the plan to provide all of the requested information to the agency. What will an investigator do upon receipt of the information? They're going to do a visual review of the claims. They're going to initially be looking at 1 year's worth of data. If this 1 year's worth of data either isn't conclusive enough or is showing too many systemic issues, they're probably going to go back and request a 3 to 5 year run of all of this same information and look at a much further look back period. Some of the things that they really are focusing on are preventative care, out-of-network emergency services, high dollar claims, and the Mental Health and Substance Abuse Equity Act claims. Still having issues in those respective areas. They're looking at that very seriously to ensure that the plan is in compliance and that the claims are being processed appropriately. Emergency services, a big thing that we are pushing for, and what we're looking at is it truly an emergency service, and did it get processed appropriately as an emergency service? In looking to determine if it was an emergency service, we're looking at the prudent layperson standard. What would the prudent layperson do in that same situation? You're having chest pains, the prudent person would say this could be a heart attack, they're going to go to the ER. You have a headache, prudent person is not going to go to the ER, but if you go to the ER for that, then if it gets denied, it's denied appropriately. But we are looking at, again, the prudent layperson determination of standards to decide if this in fact was an emergency condition and was it processed appropriately. Regarding emergency services, this is an issue that I just want to throw out there. If you have a network-based benefit and somebody is out of network, vacation, whatever, and they have an emergency service, that emergency service must be covered at an in-network benefit level. If that individual requires follow-up treatment, so now it's no longer an emergency service, then it gets processed under the regular plan design, and if the employee has to pay a higher amount out of pocket, that's unfortunately a consequence that they have to deal with. Only the actual emergency service is the one that's going to be considered as in-network and processed the same as in-network. We're looking at pharmacy. A lot of pharmacy issues coming up, so we are definitely looking at that, looking to ensure that the plans are in fact looking properly at all the claims and processing things appropriately. Are they following the guidelines in the Affordable Care Act? On the other side, we talked a little bit about fiduciary. I mentioned a little bit about fiduciary. One of the things we're looking at, jumping into a little bit of a different sector of yesterday's information, is what is a fiduciary? To be a fiduciary, it is not necessary that the person hold the plan assets, but they are in fact the one that is responsible for this plan. What does that mean? Well, if you're actually negotiating the plan, you're determining all of the information about the plan or the employer, they're most likely the fiduciary. If all they're doing is ministerial duties, which would be things like establishing a plan because they've connected to you folks have done what you need to do, are they determining a benefit package, are they amending a plan? Those are more administerial. They're not making the actual decisions on this plan and determining if this plan is doing the right thing and moving forward and signing all the contracts and negotiating the actual detailed benefit of it. So I just want to throw that out there because we do seriously look at who is the fiduciary. As I mentioned, quite often we'll call and they'll say, oh, that's somebody else's problem, and it's really not, and we have to explain to them that they are the fiduciary and they are actually responsible for their employees and the claims that are happening within that particular plan. We're looking at also at assets. So the employer holds the assets when they take deductions from the employees. They hold it in their general assets along with what they have. They're allowed to hold that there, and they don't become plan assets until as soon as they can be reasonably segregated to a maximum of no more than 90 days. We are looking at that very seriously. On the welfare side, this is something we pretty much hold true on the pension side and certain things, but on the welfare side, we're starting to be very concerned about that because, as you know, your health carriers are not going to wait, or your client's health carrier is not going to wait 90 days to get paid. They're going to cancel that benefit after 30 days. So we're looking to ensure that benefits aren't being canceled because the employer is saying, I can hold this for up to 90 days as a reasonably segregable period of time. That is not a reasonably segregable period when it comes down to an employee losing their health benefits as a result of the employer not paying it over. If there are issues, employees actually have remedies available to them under Section 502 Paren A of ERISA. So who can bring a suit? A participant or a beneficiary can bring a suit, Secretary of Labor, and plan fiduciaries. So I just wanted to throw that out there because it's starting to happen more and more where folks are bringing suit against the plan and against the employer, and sometimes they're prevailing, sometimes they're not. So just some cautionary measures I wanted to throw out from some training we had yesterday, as I mentioned. From there, I'd like to just take a moment to talk about the guide I have on the screen right now. This is our Compliance Assistance Guide, or as I prefer to call it, it's our Bible. Basically, this is what our investigators are using when there is an issue that they're going out to do an investigation. This book is pretty inclusive. There are 140, 150 pages in here. I'm not going to go through every single page, but I did want to bring to your attention a few pages that I think are very important. The benefits advisors are also using this book on compliance issues to ensure that when they're getting a call, they're given the appropriate information. Some of the things that we are seriously looking at, as I mentioned, and I just want to bring out to your attention, is the mental health parity provisions. I know that's been around for a while. I'm sure you're all well aware of it. Unfortunately, it's an area that we're seeing a surge of claims being denied on. So the investigators are seriously looking into mental health parity and MAPIA to ensure that our plans, or that the plans, are in fact in compliance. On page 41, we do talk about the mental health parity provision, so I wanted to bring that to your attention. From there, I wanted to bring you to the middle of the book. Page 62 starts the compliance checklist. This checklist in its entirety, so it starts on page 62 and it goes all the way through page 129. This checklist will be gone through if there's an investigation for any reason on a health plan. Every one of the questions in here will be painstakingly reviewed by our investigators and responded appropriately. If an investigator is going in to look for a particular issue that's been brought to their attention, and by going through this checklist they find more issues, they're just going to open the breadth of their investigation to make sure that everything is in compliance. So I wanted to bring that to your attention. We already talked a little bit about special enrollment, so that's on page 63. That's just one of the really important ones. We're seeing a lot of controversy about, again, state versus federal, and which ruling is the governing ruling on that. So it's just something I wanted to bring out there. Special enrollment is not going away, just like at this point, COBRA, to the best of our knowledge, is not going away. So I just caution the plans to ensure that the special enrollment rights are in fact being treated appropriately in the documents as well as in practice. On page 65, again, it just brings a little bit more information about the special enrollee rights. Jumping over to page 69, has to do with list billing. This is an issue that we've seen surges of calls on. A list bill, if you're listing out each individual by a health factor, cannot be done. That is a huge violation of compliance and regulatory information. But if the employer is age banding, which came about 2 years ago, we saw it first in some of the smaller groups in the smaller states, and then we started to see it bounce to some of the larger groups in other states other than Mass. I haven't seen it as much here in Mass, but I've seen it in Rhode Island, New Hampshire, and New York. Employers or health plans are allowed to age band. There are 3 age bands that the ACA has defined. Employers are allowed to age band, or companies are allowed to age band, and the employer can in fact charge different deductions based on the age band to the respective individual within the band. They can also do what's called composite or blended rating. So a lot of times the employer says, I want to treat all of my employees the same, so I want a composite, a blended rate. The insurance company can do that, and the employer can then determine what the deduction value will be based on the composite rate, or they can use the actual age banded rate. And I just wanted to bring it out there because we did get a lot of calls on that. Then the flip side to that is under COBRA. If the employer is using a composite or a blended rate, and then COBRA becomes part of the picture because the employee is now leaving for whatever reason, the employer can then charge COBRA based on the actual premium charged to them by the insurance company. So they no longer are locked into the composite rate, they're now charging the COBRA the full premium that they're being charged plus the 2% admin fee. So moving from there, I wanted to bring your attention to page 77, which then again goes into the mental health and the addiction equity part of the compliance regulation. Very, very big focus on this. I know there's an investigation going on in another region right now, huge on the mental health component. So we haven't seen it so much here in Massachusetts, but it is out there, and I just caution you to ensure that your plans are following the regs and following the issued compliance regulations. On page 99, I wanted to bring this to your attention because this is no longer applicable. This is Michelle's Law. So Michelle's Law under the regulation previously said that employers needed to maintain a dependent child that was in college that became disabled or had some kind of a disability and took them out of college. They need to keep them on the group health plan. Now with the Affordable Care Act having to cover dependents up to age 26, this is no longer applicable. So I just wanted to bring that to your attention. On page 102, we're talking about the grandfathering status. I did already talk about grandfathering, but I did want to bring it to your attention that it's here in the compliance guide, and it's one of the things that we're looking at. Is the employer validating that the plan is still under grandfathering status or not? Are they following the rules that have to be followed under ACA when the plan is not grandfathered or is grandfathered? On page 107, this is something that's come across our desk quite regularly, and I wanted to bring this up to you. Under the plan, so kind of jumping back to dependents, employers are required to cover the dependents up to age 26 under the whole guideline of the dependent care. A spouse is not considered a qualified beneficiary under the guidelines of the Affordable Care Act. Therefore, the employers, your clients, are not required to have spousal coverage. They're only required to cover the dependents. Does this become a burden in some cases? It absolutely can, because an employer can say, we are not covering spouses regardless of benefit eligibility elsewhere, and then the employee that needs to seek additional coverage for their spouse, they're not out of violation by doing that. So I did want to bring that to your attention because it's something that's come across our desk on a very recurring basis. They can cover them. No, I'm not telling you not to, but it's not a required thing under the Affordable Care Act and not to find qualified beneficiaries. 108, page 108, rescission of benefits and coverages. Huge right now. Another piece that the investigators are looking at were plans where the coverage is rescinded inappropriately, or were they not. The only time coverages can be rescinded is like under COBRA, when the employee doesn't pay their premiums. They can rescind the coverage. If there's been false data provided or fraudulent data, the coverage can be rescinded. Short of that, coverages cannot be rescinded for an employee. If they've been paying for these benefits all along, they cannot be rescinded. So I encourage you to look at that. Call our agency if you have questions. It's just another push that the investigators are definitely looking at for the compliance component. Page 111 talks about the 90-day waiting period. We talked about that a little bit in my ACA component of this presentation. Again, just wanted to bring it out there because it's here in the guide and it's part of the checklist. Summaries of benefits and coverages are on page 112, another thing that they're looking at, as I mentioned. Page 116, we're talking about the providers that must be covered under the group health plan under the Affordable Care Act. So I just encourage your clients to look at that and ensure that the plans are in compliance, that they are allowing the employees to treat with the designated professionals that are allowed under the Affordable Care Act. Page 118, emergency services. We covered that in my ACA component of this, but I wanted to bring that up because, again, as I mentioned, it's a huge push for this year. So you want to make sure that your clients are, in fact, looking at that. Preventative services, again, looking to ensure that all of the plans are following the essential health benefits, of which preventative services are one of them. We are still getting a lot of calls on that. And at this point, they can't say, well, they went in for preventative testing and the testing became diagnostic after we started to see because we found something and changed it over to non-preventative. It still must be treated as a preventative benefit for the essential health benefits required by the Affordable Care Act. If we move over to page 131, we start talking about required notices. There's a chart in here that will be very helpful to you and your clients on determining what needs to be presented to the employee population and when. We get a lot of concerns, a lot of calls about people that don't get the required disclosure notices. So I just throw that out there. We also have a guide on our website, the website I provided earlier, that will go through all of this on both the pension and welfare side. This is specific just to welfare. So that starts on page 131, goes for several pages, all of the timing and requirements. And then we move to 137, which talks about model notices. An employer is never, ever required to use our model notices. We recommend that they use our model notices because by using the notice, they are in fact ensuring that they have all of the compliance information, the regulatory information contained in a notice that needs to be contained there. The biggest example I can use, as I said, there's several notices in here, is our COBRA notice. lot of companies just download it from our website. It's a Word document. I will always advise somebody and walk them through it, that that's what they should do. If they choose not to and they leave a piece out, one of the things that gets left out quite frequently is the part when the employee may become disabled, and are they in fact including that to allow them the information about the additional 11 months that might be available to them. If any part of the notice is deficient, it's going to trigger an investigation. So I just encourage employers, so you guys to work with your employer groups to guarantee that you are in fact, or they are using all of the information in the model notice. Again, never required to utilize the model notice, but it's there and it makes your life and their life a lot easier. So that goes through the compliance guide. Last thing I wanted to finish up with, and then basically I'm pretty much out of time, running close. I did want to talk about COBRA. COBRA is here to stay, to the best of our knowledge. Everybody thought once the marketplaces came up and running that COBRA would go away. And we are not hearing any chatter whatsoever that COBRA may be going away. It's our understanding it's going to be there. One of the reasons folks choose to use COBRA, I know it's expensive, it's very expensive, is because they may be going through some kind of treatment, and the providers through the exchanges may not carry the doctor or cover the doctor that the person wants to treat with. Therefore, they want to maintain their group health plan eligibility under COBRA. That's one of the driving forces for us to maintain that COBRA is here to stay. If things change, who knows what's going to happen with the new administration? That's subject to change, but as of right now, COBRA is not going away, as the chatter had talked about previously. So I just wanted to bring that up and mention that. In a little side note, with COBRA and special enrollments, this has been coming up a lot in the last year or so, where an employer is doing significant layoffs or whatever, for whatever reason, they're separating an employee and they're offering a severance benefit, which is awesome because it's great that they can do that. But the problem is if the severance benefit includes a component of the COBRA premiums, the end of the severance arrangement, while the employee is either paying nothing or whatever they paid as an employee under the severance, the end of that severance benefit is not a qualifying event. The qualifying event is the beginning date for COBRA. Therefore, at the end of that period, the employee has to either pay full premium under COBRA or have no health insurance because they cannot get on the exchange at that given point in time on the marketplace, because the marketplace will not allow that as a special enrollment. Special enrollment was when COBRA first became effective. Just throwing it out there because we do get a lot of questions and concerns about that, and it's very difficult to explain to somebody, yes, you're losing your job, we understand all of that, and this is a great opportunity, but let me tell you the flip side and make sure that you really do look at this appropriately and follow what you need to do that's best for you and your family for financial and medical reasons. I just want to sort of end with that. So at that, my presentation is done. I do encourage you, if you have questions, to contact Kate. My direct phone number is 617-565-9639. Again, I'm a Senior Benefits Advisor in the Boston Regional Office of the Employee Benefits Security Administration. And our main telephone number in Boston is 617-565-9600. I want to thank you for your time this morning. It's been a pleasure, and I do encourage you and look forward to any follow-up conversations that we may need to have. Have a great day. Thanks.